let's get to yet another judgment debt matter that's been put on Hanna Tetteh, who is now the Foreign Affairs Minister, but at the time was the Trade Minister. And this is a judgment debt that the Ghana National Procurement Agency took some loan from the New World Investment Limited of eventually they were supposed to pay 2.5 million cedis in settlement after the firm went to court demanding 4.3 million cedis from the procurement agency. The payment was made on the orders of the minister, but the commission says the company deserved a lesser amount. And Hanna Tetteh is being indicted of causing financial loss. I'll read you just this portion of it. But what ought to be noted is that the investment firm claimed the debt had risen to 4.3 million cedis at the time, and Hanna Tetteh secured an out-of-court settlement of 2.5 million cedis, which the finance ministry paid, but the procurement company agency says what the company ought to have received should have been 1.6, nothing more, nothing less. The Judgment Debt Commission says the then Minister of Trade, I'm quoting, the then Minister of Trade, Ms. Hanna Tetteh, under whose supervision the agency falls, later intervened and had the matter settled out of court, leaving in its trail a judgment debt of 2.5 million, which is 25 billion old cedis, which the Ministry of Finance was made to pay to the plaintiff. The settlement amount, 2.5 million cedis, was arrived at without using any formula, and that's the concern of the commission. It was arrived at without using any formula. It was imagined without any basis. This settlement made the state incur an extra debt of 876,000 Ghana cedis, which would not have been paid if the ministry had allowed the case to take its normal course. It was the taxpayers' money that later became the victim of the misjudgment and wrong actions and or inactions of some few public officials. This is the Judgment Debt Commission's report. Serious what?
Generalization. I mean, you see, first of all, we are being told that the Minister of Trade intervened whilst the case was pending in court.
Right.
Indeed, that has been one of the reasons why we have got to pay. I don't even want to call it judgment debt. These are unnecessary negotiated debts. If the case is pending in court, it means that it is against the Attorney General. And so are we being told that whilst the Attorney General's department was defending the suit in court, a minister intervened, or I will use the word interfered, and as a result, such a huge amount of money was paid without the knowledge and all the approval of the Attorney General? I find it difficult to understand. That is why I'm saying that I still have serious difficulty and is leading into a doubt in my mind.
The agency had borrowed 1 million Ghana cedis as loan. It was able to pay back 550,000,
yes,
leaving a balance of 450.
Yes.
And that is the outstanding amount that became a matter of a judgment debt.
Yes, so that is why it's necessary that, and we are not told whether Ms. Hanna Tetteh was given the opportunity to appear before the commission to explain herself. Under what circumstances was she able to interfere with the pendency of the suit?
No, you see, the investment firm had obtained a 1.127 million Ghana cedis judgment debt.
Yes.
Okay, in 2007 against the
yes, and they went back to the court.
Okay.
But when you read,
we went back to the court in 2010.
Yes. When the minister Hanna Tetteh, under whose supervision GNPA force later intervened and had the matter settled out of court.
That's right.
This is a definitive statement by the commission.
That's right.
So I don't know whether they went back to the court with a new entry of judgment based on the interest that had accrued, or they commenced a fresh action, which I think should have been maybe the case. Because otherwise, if you go back to the court, that because interest has yielded, all you do is to amend your entry of judgment and then file it. So I don't know that if the case was settled or determined in 2007, what else might have led to the company going back to the court, which will then have resulted in... So in this case, even the Attorney General's department should have also been invited. Mm-hmm. That is why I'm saying that I still find it very difficult to confirm that this is part of the work of the commission, but I have been assured that it is, and therefore I think it's in the interest of Ms. Hanna Tetteh, because you see, the danger is that under the Constitution, when the commission presents its report, nothing can be done about it unless 6 months have elapsed, within which the president can file or publish the report together with a white paper. So let's say that will lead us to, I think, October or so, this year. Mm-hmm. If the president decides to exhaust all the time, then after that, you can't do anything about it until another 6 months. No, 6 months.
Upon the publication, 6 months.
Yes, you need
then
another
it becomes
6
a judgment
months.
Of the High Court.
Yes.
Then you have 3 months within which to appeal to the Court of Appeal.
So you are talking about 1 year and maybe another 3 months.
Somebody could block her, attempt to get back to Parliament.
And that is the point.
Because adverse findings against you means you cannot contest as a member of Parliament.
That is why I'm saying, whether it's wrong or not, it has to crystallize into the judgment of the High Court before you can put anything on it.
Well, Nana Santibidi to contest that under a certain circumstance, and I think that if the justice of the case demands, you should be able to go to court before that.
On what basis?
Particularly for those who are not invited.
No, what is the value of what are you taking there?
What law?
No, what are you taking there? That somebody has made allegations.
When you are able to obtain a copy, you don't wait for the...
If you obtain a copy, how are you going to certify? First of all, the report, even as is with President now, until the publication and the white paper, it's nothing. Nothing can be put on it in a court of law.
Right.
It is until it has crystallized into the judgment of the High Court.
Right.
And the white paper had not set aside portions of it. And those adverse findings still touch on you. That is the only time you can put anything on it in court. As it stands now, it is just a mere criticism.
I think once the report
but again, it does look like
out, I think you can take
it does look like any variation of the report of adverse findings by a white paper does not absolve that person. And so, the disqualification it gives you, it puts on you, remains.
Well, the problem is that the Constitution only mentions white paper without telling us the effect of a white paper.
Okay.
For me, it only speaks of adverse findings. But if the government issues a white paper and says that I have set aside this portion...
But in practice, especially from other countries, it's really, the focus is more on the white paper than on the report.
Yes.
Right. In Ghana is the report.
Okay.
No. But if the white paper sets aside any adverse finding, you can't put anything on it.
Let's hear Abraham on this.
It doesn't exist anymore.
His concern is that a minister intervenes and does all of these things. And the people say, look, you have money to get them 2.5 million. We insist that if the matter had gone its full length, they would have been entitled only to 1.6.
It's a bit intriguing with Hanna's case. You will notice that when you're reading the report, you will notice that the company went back to court and demanded 4.3 million Ghana cedis.
Right.
The question is, was Hanna Tetteh misled by this 4.3 million Ghana cedis? I'm sure Hanna Tetteh, paying how much? 2.5, would have said that he has saved Ghana some amount of money.
Half of it.
Yes.
Also.
So, was she misled by the 4.3 million cedis that the company went back to court and claiming? I'm sure, and I want to borrow some of the ideas from upon that. It would have been better for her to do this out-of-court settlement in tandem with the Attorney General. Because all this information about how much to pay, how much not to pay, and the genesis of the case because this case started when she was not in office, would have been available at Attorney General's department. Her attempt to settle out of court is perfect. There's nothing wrong.
The suspicion by critics is that this is a way some of the people who lead get some money. So that's why some politicians are desirous of leading the settlement, so that at least they get something into their chest for their campaigns.
Okay, I don't know that. I've not seen them.
Is it just for campaign?
But I know that you can settle while the matter is in court. That I know. We all do it. But when you look at the situation as we are faced here,
but the settlement is between parties.
Yes, and she's the Minister of Trade, under whose ministry the National
GNP.
Procurement
Agency
falls.
So she could lead the way. And I'm saying that she may have been misled by the 4.3 million. But I think that she could have done better if she did this.
But we haven't heard from her.
In
that
tandem
is the
with the
problem.
minister.
Interesting.
We haven't heard
Maybe
from her.
she's also waiting for the official report.
Minister of
But Gabi,
Attorney
what do you
General's
make of the conclusion? Or let me hear from you first, AB. What do you make of the conclusion and the findings that the commission makes? The commission says, let the procurement agency or its officers be made to cough up this 800,000, which is a financial loss to the state. And Hanna Tetteh is left.
I perfectly agree with that conclusion. And that is why I had a problem with the conclusion of Nana Akufo-Addo. You see some consistency here? That for Hanna Tetteh, they were stating the facts and left it there. Nana Akufo-Addo, they stated the facts. He didn't defend. He didn't defend. There was a defense in London. He didn't follow up. These are facts. But it was wrong for them to then conclude the way they concluded. Hanna Tetteh did not appear before them. Rules of natural justice. Yeah. So they couldn't have concluded and made any comments on her. You get the point?
Yeah.
So this conclusion on Hanna Tetteh is right. That same principle should have been used to apply to
Gabi, how do you understand that? You say a particular individual is responsible for financial loss. Yeah. Then you say someone else should be made to pay.
She was not heard.
I think it's probably the power model of
Gabi, speak up. A power model of what?
Maybe the logic. It beats me. It beats me because it really wasn't the GMPA that led the negotiations. But I want to stick my neck out to defend Hanna Tetteh to a point. Because first of all, we haven't heard from her. Yeah. For all we know, she had sat with the Attorney General, and then it was said that, okay, so you try and see if you can negotiate, and then report back to us, and then we will take that to the Ministry of Finance. Maybe that was done.
But the people disagree with him. No. They say you got 2.5.
No, but
what they were entitled was 1.6.
Should have been called.
No, I'm saying that, and I don't even think that the commission can conclude as to what they were entitled to. Because how do you conclude?
It's not the commission that is concluding.
Who is concluding?
It is taking the facts and giving them to you.
Okay, first of all, no, I'm not so sure because they've gone to court demanding 4.3 million.
Right.
Okay. Now the court has not concluded that they should be given 1.6 million. So how do you conclude that 1.6 million was due them? That's my problem.
Those who are fighting the case,
are
fighting it on the strength that it is 1.6 that is due them.
Who are those?
Those who are fighting the case
agency.
are not different from the minister.
That's
the agency. But I'm saying that. But when you go to court, the agency is saying we'll give you 1.6. They are saying they deserve 4.3. So you can't conclude that it is the agency that is right.
Okay, in this case, the agency believes in this case, like in the Chachu counterclaim, that it is a strong, case.
Yeah, but I'm saying the fact that, but you go to court because you believe in your case. Some parties went to Tallency because they believe they could win. So that's so that's not the point. And what I agree with is we need to be told the formula that they used. But if there was
commission says there was no formula, it was imaginary,
now,
and there was no basis.
Now that, of course, you can't argue against it. But I want to step back a bit, and you see it in the Obed Asamoah case when we get to it, and you see it in the Hanna Tetteh case, and to a point you see it in the in the GMPC, the drill ship case, and also the Kufuor case. You know, we've had two matters of judgment debt in Ghana. And really what created the controversy was actually people being paid for things that they did not deserve. Okay? Now, in these 3-4 cases that we are talking about here, it is not an issue of they not deserving, but it's an issue of procedure and also, to a point, quantum. Yeah? Now, on the Hanna Tetteh case, and I think that's where we have to step back. If you look at the Obed case and the Hanna Tetteh case, in both cases, it was negligent to a point by the Ministry of Finance. And I'll say, this is, why am I saying so? In the Obed case, judgment debt was given. You were supposed to pay at a certain time. No payment was made. And then it balloons into something else. In the Hanna Tetteh case as well, in 2007, judgment debt was given. It was not paid, and it balloons. So I think in dealing with it, we should also be looking at how the Ministry of Finance, you can talk about resources and the rest of it, how we don't somehow, if you like, prioritize some of these judgments that we have to pay because you have no option but to pay. And then they end up, escalating to certain levels that we end up paying more. Because whatever the case may be, you will have to pay.
Okay.
So if we don't make it, I think I would look at it from that point.
What do you make of this one too?
Well, I have to be honest. I just read that chapter, you know, so I am not going to be able to do a serious analysis. But something strikes me. The commission found out that the company, is it New World, they used a certain interest rate on their own, unilaterally. They didn't show the committee any agreement that the two sides had agreed that this is the formula that we'll be using. I don't see anywhere. The only thing I saw was the need for the tax authorities to investigate whether they paid their
Apparently
tax.
they didn't pay.
Yes, so
they
didn't
pay.
But is that enough? Just that? It appears that the interest rate they used ballooned the judgment debt that they were paid.
You mean?
I tell you what, I have a personal worry about some of these things. That the state is paying such huge sums of money in judgment debt, and we don't take tax out of them. The tax is supposed to be taken out of source.
You should take it before you even pay. Absolutely.
It's supposed to be taken out of source.
That's a good point. That's an excellent point.
And you see,
That's an excellent
also,
point.
my worry is that you
That's an
don't
excellent
make these
point.
payments, and then later on you lament that, oh, I should have
That's
taken
an
tax from
excellent-
him,
oh, gee,
or
yeah.
I
That's an
shouldn't
excellent
have paid this much interest on it. Once you pay, it is an admission that you have accepted the proposal, and I'm sure they will
Yeah,
have signed.
so beyond the need for them to pay the tax, I think that the decision on their own to use a certain formula, it's itself.
And that formula was accepted
Well,
by...
that's-
by
by the
the,
payment.
The
the
commission
other party.
says
It's a
without
difficult
a
thing for me.
formula. That's
Yeah,
what the
yeah,
commission
yes.
said. Without a formula, and that it was imaginary,
By
and that it was without basis.
By the
Very
state, by
important.
the,
who
yes,
imagined
by the
it?
state apparently
state
acquiesced.
The intervention of Hanna Tetteh, that's what it says.
And Hanna Tetteh has not been heard.
no.
Yes.
Me, I have.
So I think I will hold my fire
That's
there,
what
but
Abraham Bamba just said.
this appears to be a very bad
You see?
case.
But he said that because she was not heard, she's not been found, no adverse findings. She's not been asked to do the refund. But it is the other people who have been asked to do the refund. But like Yao points out, the adverse findings still hang against
yeah, they are
her,
enough.
and she may not be able to go to Parliament. That's terrible.
Unless it gets
I'm
a
sure,
court of
what
appeal.
I'm sure she will
but-
fight it.
But
The
the,
financial loss has been caused
Cost.
as a result of her intervention.
But-
Financial loss of
Absolutely.
800, yes,
Something.
800,000.
but there's this point that the
Right.
officials who took that decision to use the loan
Yes.
meant for the importation of sugar to augment the capital of the company should be surcharged for the loss incurred by the state. They should also be made to account for how the loan was utilized.
Exactly.
This is targeted at the officials.
That's the point we have been talking about now.
I think we need time to interrogate this thing a bit
all
more
right.
thoroughly.
Thank you very much, gentlemen. We'll take a quick break here. When we return, then we'll do Dr. Obeda Samoa and the judgment debt of over $4 million that he also has been found to have, caused financial loss. And then we'll move on to do a bit of some talency work. We'll be right back, whether or not violence begets violence.